Thank you so much, everyone. Of course, between sessions, I know we haven't been doing a transition time. Please feel free, of course, to step out, grab another coffee, etc. We will be setting up lunch here shortly for after this final session of the morning. I won't introduce every panelist during this session, just in the interest of time, because they're so interesting and all have, of course, extensive backgrounds. But I'll just introduce our moderator, Professor John Lee. Professor Lee is an associate professor of law at the University of Oklahoma College of Law. His scholarship is on professional regulation, and it's appeared in the Boston College Law Review, the North Carolina Law Review, and the BYU Law Review, among others. He currently serves on the National Conference of Bar Examiners Content Scope Committee and the Drafts Prototype Questions for the Next Gen Bar Exam. Prior to arriving at the University of Oklahoma, he was an award-winning teacher at the University of North Carolina School of Law and, of course, the University of Minnesota Law School, which we're incredibly excited to have him back visiting. Please welcome Professor Lee.
Well, I will introduce Professor Capers is at Fordham Law School. He is the John D. Frierick Professor of Law, and so he will start us off.
Okay, and if it's okay, I'm just going to sit from here. I know some people might not be able to see me from the podium, but that's fine by me. Thanks for inviting me, Josh, Leah. This has been amazing. And I'm going to start off with an apology. I had these beautiful notes with me on the plane, and somehow I left them on the plane, which I realized this morning. But I think I'll be able to manage. So in my brief time, what I want to do is sort of expand upon an essay that I published in the Minnesota Law Review a couple of years ago. That essay was titled The Law School as a White Space, and it explored sort of the many ways that too many law schools sort of function as white spaces, from the demographics of students and faculty to even the architecture. Although race was sort of the focus of that essay, the ambition was much larger, and it also included reimagining the law school from the bottom up, including what law schools teach and how they teach, which relates directly to the topic of this panel. And if you don't mind, I'm going to quote directly from the introduction I wrote in that essay, because I think the goal I set for myself in that essay is the same goal I have today, the same goal I have for this panel. And that goal is to, quote, check and even disturb the very foundations on which most law schools are built. And brief parenthetical or bracket, there's a lot of analogy to buildings in this introduction, which also dovetail what the dean was talking about earlier. It is to re-examine the walls and the insulation that allows some students to thrive while keeping others out. It is to test the air filtration system to make sure it has not become stagnant with time. It is to see where repairs are possible while recognizing that what may be necessary are sledgehammers, wrecking balls, and new tools. May even need an entire demolition. The end goal is to dare law schools, to dare all of us to imagine a new construction, an entirely new law school. In short, the end goal is to imagine the law school no longer as a white space in terms of demographics or what is taught or how it's taught, but a white space as in a blank page, at once empty and full of possibilities. What would it mean to rethink the law school from the bottom up? What would it mean to create or recreate the law school so that it is cosmopolitan and then some, a place where intellectual curiosity thrives, where change and challenge are celebrated, where education itself is a practice of freedom, to borrow from bell hooks, and perhaps most importantly, where there is no need to tout inclusivity because everyone already belongs. So that's from the introduction to the essay. What I'm going to do in my brief time is talk a little bit more about how law is taught, and then segue to what is taught in law school. But also going a little bit beyond my essay, I'm going to focus a little bit on criminal law, which is my particular area. And finally, if I have time, I might not get to it, maybe a few words about how we hire the people who teach at law schools. So first, how we teach. Here I want to borrow from the work of Elizabeth Mertz, a legal anthropologist and a pioneer in the field of law and language. She basically did a field study. She went to all these law schools across the country, recorded them, studied the transcripts, really trying to figure out how thinking like a lawyer is taught in law schools. And she focused on contracts classes. And what she found won't surprise anybody in this room, but hopefully it's still illuminating. What she found was that, at law schools, and training students to think like lawyers, we're basically training students to focus on form, authority, and legal linguistic context. So what's the issue? What's the holding? What authority did the court rely on? What authority does the court have itself? What level of court is it? And all of these things are important to be sure, but thinking about a lawyer also involved training students to unlearn things. It involved training students to discount things like morality or content or social context. We too often are sort of training students to think like, oh, class doesn't matter, or gender doesn't matter, or ability doesn't matter, or sexuality doesn't matter, or race doesn't matter. It's a way of teaching students to sort of like treat as irrelevant all of these things and sort of almost become these objective beings where all these things about individuality and context cease to matter. Lonnie Grenier, I want to bring up, because she made a similar finding focusing on how female students felt at the University of Pennsylvania a couple of decades ago. So women students who excelled, she found, tended to be the students who, in a way, de-sexed themselves. They found a way to argue like the boys, discuss things like the boys. I think this is why she titled her book, Becoming Gentlemen, because at law schools, women to excel had to become gentlemen. And, this applies across the board. So I really see two problems. When we limit students' views on what matter in law school or what matters in law schools, we're sort of limiting their vision of what the law should and can do and what the law should attend to. The other problem is we make them limit themselves. So thinking like a lawyer becomes thinking about a particular kind of lawyer that has gender and class and race implications. Now for what we teach. I mentioned my area is criminal law and also evidence and criminal procedure, but I also think of myself as a race scholar. So in my article, I focused sort of on race a little bit in what we teach. And as we all know, and the dean mentioned this and several people have mentioned it, since the killing of George Floyd, there's been a lot of conversations at law schools about adding race to the curriculum. And, law schools have responded. There have been so many conversations. I've been on those committees. And for the record, I don't want to dismiss the arguments about bringing race into the classroom. But for me, the problem is slightly different. It's not that race is too often absent from the classroom. For me, it's there in black and white. The problem for me is the whiteness of the curriculum goes unsaid. It's embedded in what we teach. It's embedded in the common law system we inherited. It's the way we teach students that the Constitution is the highest law of the land, while at most only giving passing reference to the fact that the Constitution is very white in terms of who drafted it and what it means and what concerns it cared about. We problematize the reasonable person standard in torts in criminal law, but then we sort of move on, and it doesn't factor into the rest of what we teach. Ian Main at Wisconsin Law has even pointed out the sort of the history of how criminal procedure rules developed versus how civil procedure rules developed is so connected to race. But again, I just want to say, my argument in the essay, and even here, sort of goes beyond race. So it sort of goes to what Duncan Kennedy refers to as, quote, the endless attention to trees at the expense of forest. So much of law school, and again, we heard it, it's like, even in the session on admissions, attention to detail is important, but sometimes attention to the big picture matters too. So we spend so much time teaching students what the law is and the details, and sometimes we dull their interest and suppress their interest in what the law can be. And part of my point in my essay is we sort of, sure, we teach students how to be agents of change, but usually at the margins. It's like rearranging the apples on the apple cart without really upsetting the apple cart. So I mentioned up front, and I'm sorry, John, I'm not keeping track of time at all.
Keep going.
So, I mentioned up front I wanted to say a few words about criminal law. I'm going to do that now. So, trust me, I could go on and on and on about what I teach in criminal law. The rationales for punishment, actus reus, mens res, rules of legality, maybe a little bit on substantive crimes, and how poorly this maps onto the real criminal system. But I'll bracket that for now. My real argument is about the ambition of a typical criminal law course, because the ambition of a typical criminal law course is really to help or hope that some students will graduate and practice criminal law. They'll become prosecutors, or they'll become defense lawyers. All of that involves them being participants in the criminal system. But I think increasingly, students are beginning to recognize that the criminal system is so broken and flawed at its core that it's almost kind of strange we're teaching students to practice something that we are sort of saying is fundamentally flawed. And I think law schools have yet to pivot to actually teaching students how do you completely change a system? How do you completely change a system? So I could say a few words about hiring, but I think you know what I'm going to say about hiring. We're just replicating the status quo because so many of the people we hire come from one school, Yale. But instead, what I'm going to do is just, I think, gesture towards sort of the bigger picture of reimagining law schools, which I do in the essay. And the essay really concludes with an imagination. But for now, I just want to mention a few things I was thinking about as I was listening to the panelists this morning. And it's really going to the idea of if we could sort of take a step back and really imagine a law school as a blank slate, forget Langdell, forget everything that we experienced in law school, and really could step back and think, if we were starting a law school new, what would that look like? That's what I want to encourage people to do. And just a couple of questions I want to throw out there. Would we still have the same 1L classes? Crim law, torts, property, con law some places. Would we silo classes the way we do? So that you learn one thing in one class, and if a student asks a question that goes beyond that class, we sort of shut it down. Would law school still be 3 years? Would it be would we have more skills? What would the balance be? Might we rethink the balance between having practitioners and full-time law professors, or would we sort of keep it the same? Would we still have grades? And I was speaking to some students last night at dinner. They were opposed to grades, but maybe that was just a small sampling. Would we even have the bar exam? Or would we imagine a bar exam that sort of, might be different depending on what the student plans on doing? If a student who plans on being a general practitioner might have the normal bar exam. A student who plans on going into, being a prosecutor might have a very different exam. You might say, you don't need to know trust in the states. So, you don't need that on your bar exam. And would we just allow different schools to experiment and do different things to help different students sort of become whatever they want to become, as opposed to sort of saying, this is what a lawyer is. So I'm going to stop there. I've probably gone on way too long. I just wanted to throw out ways and get things, get the ball rolling.
Thank you so much. So I think we are going to transition. You have slides, correct?
I do.
Yes, so Professor Susan McMahon from the ASU Sandra Day O'Connor College of Law. She is an associate clinical professor of law there, and she is going to present our next one.
Great, so thank you so much, Professor Lee. I'm beyond honored to be here today. Thank you so much to the Minnesota Law Review for putting this panel together. So my argument today is that legal analysis, as it has traditionally been taught in the first year, gives students the impression that law is neutral and just, when in reality, as Professor Capers has been alluding to, and I think our presentations kind of coalesce really nicely together, in reality, law can and does perpetuate injustice and bias. And so I argue that law schools need to not only train students in how to do legal analysis and these legal analytical skills, but they also need to give students insight to see where law has gone astray and the tools to help them fix it. So I'll start by outlining the contours of the problem, and in keeping with the theme of our symposium today, how all of those problems started with Christopher Columbus Langdell. Okay, so I teach legal writing in the first year, and when people ask me what I teach, I say basically it's about understanding and applying rules. I help my students identify rules in cases. I help them take a series of cases and see the unspoken thread that runs through them. I help them take rules and apply them to new sets of circumstances. And I imagine that many of the other classes in law school, especially in the first year curriculum, do the same. We say that specific courses don't really matter that much, that the main thing that we're trying to do is to teach students to think like lawyers. And any definition of thinking like a lawyer requires mastery of rule-based reasoning. This way? Or this way?
Computer is right here, so if you point the computer.
Maybe that's in the way.
I can do it. Sorry.
Maybe the podium's in the way.
And there he is. So we can trace all of this back to Langdell's curriculum. Langdell envisioned law as composed of limited general principles which can be discovered by close examination of appellate opinions. And once those principles are discovered through the inductive process, then they could be applied syllogistically to neutrally resolve any legal question. Now, I think we've all moved on from this idea that law is a science, but has our legal analysis pedagogy really moved on from that? That foundational idea that we can derive rules from cases and apply them to new situations, that's rule-based reasoning, that's IRAC. It's at the heart of a lot of the legal analysis work we ask our students to do and what we assess them on. And while that work is certainly necessary, right, any young lawyer has to know how to find rules and how to apply them, it also comes with costs. And so I'm going to outline 4 of those costs here. And I might just abandon the PowerPoint altogether, but I'll leave it up right here. So the first cost.
You're between the computers, so you put your computer over there, maybe.
Oh, here we go, the neutrality problem, awesome. So Langdell's explicit goal was to make law more of a science, to make legal reasoning more like the scientific method. So that sheen of neutrality and objectivity is still attached to rule-based reasoning because when a judge takes a set rule and applies it to facts, it often seems like the result that the judge is coming to is this one correct result. So Oliver Wendell Holmes and the legal realists made quick hay of this, right? They showed in various ways that rules could not and do not decide cases, that rules were too general to decide cases, or that judges had multitudes of rules to decide from, and that something other than rules was often driving the results of cases. But does that realist insight really come through when we teach students how to draw rules out of cases and apply them to new sets of facts? And I'm going to use a case that I teach to demonstrate this, White City versus PR Restaurants. And this is the case that asked an essential question. Is a burrito a sandwich? The judge said no, it's not. And here's the rule he used to apply, which he drew from the dictionary, that a sandwich is 2 thin pieces of bread, usually buttered, with a thin layer spread between them, which is a weird, weird rule. We'll get more to that later. So if a student reads only this opinion, they're left with the impression that this is just the rule, right? This is what a sandwich is. But when you read White City closely, you see a footnote. And in that footnote, the judge says that he had multiple dictionary definitions to choose from, as well as the affidavits of sandwich experts. And just a side note, that is what I will be in my next life, a sandwich expert. So I did some investigating, and I looked at the dictionary that the judge had used to get this sandwich definition, and it turns out in that same dictionary, there's another definition of sandwich: 1 slice of bread covered with food. Now, if the judge had picked that definition, he very easily could have found that a burrito is a sandwich. A burrito is a slice of bread covered with food, just rolled together, right? And so now an opinion that on its face seems rule-driven, the neutral result of application of law to fact, instead turns on this choice of a rule. But a student wouldn't know that from reading the opinion alone. She's left with the notion that this is just an example of a logical approach to solving problems, neutral application of law to facts. I'm just gonna, this way? Okay, here we go. Second problem, frozen imagination problem. Okay, so learning legal analysis in this way freezes students' imaginations as to what is possible. That continuous practice of legal analysis, of identifying and applying rules, gives a legitimacy to our legal ordering of the world that drowns out alternatives. This was a crucial insight of the critical legal studies scholars that I'm relying on here. And when we go through the rituals of legal reasoning without a sustained critique of that process, students develop a sense that things are the way they are, and they fear that to change them might just make all this worse. So let's go back to White City to illustrate this. When I teach this case, I pose some hypotheticals to students, right? We have the White City case. Okay, now, is a wrap a sandwich? Is a hot dog a sandwich? We take the sandwich rule and apply it to all of these different hypotheticals, and students talk about the shape of a sandwich, the interior, the exterior. This is all good, helpful work. I'm not suggesting that we stop doing this kind of work. But then I ask the students, well, is this a good rule? This thin bread, buttered for some reason, sandwich, like, is that a good rule for what a sandwich is? And they stare at me when I ask this question. And one student, I just taught this class a few weeks ago, and one student said to me, why does that matter, whether it's a good rule or not? So these are students who are halfway through their first semester. They're already so used to the practice of putting things in and out of categories, what is a sandwich, what isn't, that normative substance of the rule, it no longer matters. And then the students just accept it, accept the rules, and then they move on to what they see as the legal work. Okay, so that invisibility of alternatives, that freezing the imagination problem, it leads us to a particularly nasty side effect. It can also make existing power imbalances and injustices embedded within the law invisible. This is the justice problem, that concerns about justice or morality or rightness get pushed aside. And without that normative assessment of the rules, students rarely see how this lattice work of legal rules can cement injustice and bias. Now, a burrito might be a somewhat silly example of this, but it provides actually a somewhat powerful illustration, because by putting the facts into different categories and ignoring the assessment of the rule, the students were glossing over some very real biases that likely led to the adoption of the rule that led to a burrito not being a sandwich, rather than the rule that would find that a burrito was a sandwich. Was the judge motivated by a cultural sense that a burrito is a Mexican food and a sandwich is a white food, right? Or a neutral food? Is that why the judge picked the sandwich definition he did? Maybe. And at one point in the opinion, the judge actually notes that common sense dictated part of the outcome. Well, what is that? What's going into that common sense? But when students don't view rules with this critical lens, they gloss over all of that. They're not taught to unearth assumptions or biases or injustices that might be hidden there. And then we have the fourth and final, and I would argue probably most even consequential problem with the traditional approach to teaching legal analysis, which is that this legal analysis pedagogy trains a student to look to the past, to marry her arguments with the things that have come before, but it does not develop her skills as a change agent. In other words, legal analysis is at its heart status quo reinforcing, and students are rarely taught instead how to make deep, radical change of the kind that today's world seems to require. And that is because legal analysis itself, at least in the way we traditionally think of it, and at least in the way that Langdell thought of it, is backwards looking. The resolution to a problem depends not on a theory of justice or economics or social well-being, but instead, often the only question we ask is what have past decision makers, what have judges, what have legislators, what have regulators, what have they told us about what to do? And this marriage of solving current problems by tying them to the past is unique to law, right? Science consistently questions its past findings, and through the scientific process, tests and retests hypotheses to determine whether they still hold water, but law does nothing of the sort. It is enough to say that this case should be decided in favor of the plaintiff because this other case was decided in favor of the plaintiff. And yes, we do need to train students in this way to prepare them to be lawyers, to prepare them to operate in this system. But if we train them only in this way, then law schools are telling students implicitly to respect the boundaries, to prioritize consistency within doctrine, to learn how to preserve the status quo. Students are dissuaded from making arguments that push the limits of the law, that incorporate different methods and different worldviews, that ask different questions than the ones allowed for by law as it exists. So, how do we fix this? What do we do differently? I argue that we need to teach legal analysis plus, and I think there are two steps to this plus. First, we need to disrupt students' sense that law is neutral, objective, and usually okay. And great work has been done on this front by many scholars. I am standing on the shoulders of giants here, some of whom are on this panel with me. But here's my small contribution to this literature. Let's simply ask students to assess the value of their rule. Let's ask them the questions about it. Who does this rule advantage? Who does it disadvantage? Is that the right balance? Why? We can ask students the questions I asked of the sandwich rule. Is this a good rule? And we push past students' hesitancy and get them to see why that matters. And I think it's important that we do this work not just once or twice during a semester when a rule is particularly problematic, but that we do this work consistently. Because by doing it over and over again, professors can disrupt students' ideas of rules as fixed and impermeable, and instead can reveal the value judgments that underlie the rule. Students get in the mental habit of seeing rules as exercises in power distribution, as policy preferences, rather than neutral and objective statements of principle. And they practice not accepting rules as they are, but imagining what they could be. And then the second step is to empower students to make change. So once students have new ideas of what the rules can be, they're going to want to bring them into being. They're going to want to disrupt this system and change it. How do we give them the tools to do that? One way I would suggest is to reframe some of the skills that we already teach and discuss them explicitly as the way that law changes and evolves over time and the way that change gets made within the boundaries of the law. So going back to the sandwich example, we have that normative conversation, and we all agree that a sandwich with 2 thin slices of bread that is buttered is not a good sandwich. This is not a good rule. But then we talk about how lawyers could argue for a new rule in a different kind of case. So I start off by giving students a bunch of other cases that discuss what a sandwich is, that provide different or nuanced definitions of a sandwich. And they can find, in those cases, a new implicit rule, often a better rule than the White City case offered. And through this process, they can see how the addition of new holdings can shift a rule, can help it evolve, and that when they have multiple cases with multiple holdings, they can make arguments, different kinds of arguments about what the rule actually is. But we can also have conversations with students about more creative ways of pushing law forward. How can we exploit the flexibility in legal rules that the realists taught us about to argue for shifts in completely new directions? How do we pry open that closed loop that is law, where we only look to law, we only look to what past decision makers have made, have decided, and argue for consideration of other pieces of evidence so that we can shift law in new and better directions? And I think those conversations can lead to some really great places. Students start off very skeptical, right? Like, again, why does it matter? But then they come out of these conversations feeling powerful, feeling as if they have a role to play in the evolution of law, and feeling as though they can use their power as lawyers to change things for the better. So I'll stop there, and thank you so much for listening.
Thank you so much. We want to now hear from Professor Bob Kewen, who is going to speak on clinical education. He is the head of the clinical program at WashU.
Thank you very much. I want to ask why in law school there is not more clinical education, including a required clinical experience that prepares every student for law practice through assisting clients. And as I hope to show empirically, the failure to do that is not because it isn't wanted and valuable. And along the way, I want to knock down a few tropes I think they're often put forward as an excuse for not moving forward. Whoops. One thing is very clear. The legal education is far, far below other professional schools in only requiring 6 credits of experiential training, as Judith Gunderson mentioned this morning. Where only 1/14 of our total credits are in this sort of skills training, and we have no mandate that training involve the representation of actual clients. And this is not to even mention that these other professions have post-graduation apprenticeship requirements, as do pretty much every other country in the world. So why is it that legal education in the United States requires so little professional skills training and no clinical training requirement? Well, the lack of training is not because recent graduates haven't found such courses useful. As this chart shows, based on a survey, clinical courses were rated behind only employment during law school and the types of experiences that were most helpful for new lawyers' transition to practice, and ahead, as you will see, of the typical law school classes that we focus so much attention on in the 2nd and 3rd year. And in the same study, these clinical courses were found to be helpful in transitioning to practice regardless of where the new graduates started their legal career, although as you can imagine, they're most helpful for those going into public interest or government work where they're not sort of brought along slowly as young associates. And as you can see from this NALP study of the possible modes of practical training, it's clinics and externships with client contact that were judged the most useful to these new lawyers. And so, not surprisingly, recent law grads overwhelmingly believe, and we've even heard it today in some of the introductory comments, that changes are needed to the legal education system, and the change these recent grads believe is most important is one incorporating the students' clinical experiences as part of their legal education. I also should note that new graduates overwhelmingly rank the specific practical skills, abilities, competencies that students encounter in clinical courses ahead of any of the knowledge domains learned in the classroom. So as mentioned earlier, when a 2011 study by the National Conference of Bar Examiners listed over 100 skills, abilities, and knowledge domains, and they asked of new lawyers which were the most significant to their work when they began practice. 25 skills and abilities were ranked ahead of even the most significant knowledge domain. And I should note that in a subsequent 2019 study by the NCBE and by a 2019 California Bar study that looked at the same, they yielded very similar results. So I think it's clear that what lawyers need most when they start out are these skills and abilities way ahead of sort of memorization or rote knowledge of black letter law. And legal education's lack of more clinical training also can't be because employers don't want more practical skills training in the graduates they hire. A survey of hiring partners and hiring associates that were involved in the hiring process overwhelmingly said that new lawyers lack necessary skills and that those skills could be effectively learned if they, in fact, were enrolled in and taught through clinics and externships. And judges, whether state or federal, trial or appellate, who see firsthand the results of our legal education system also agree that the change that would most benefit legal education is more practice-oriented skills coursework. We've heard discussion earlier about this wonderful large study by the Institute for the Advancement of the American Legal System that showed the importance of what is learned in clinical courses to help new lawyers begin their careers and obtain their first legal job. And much like the NCBE and California Bar surveys, it was trying to determine what are the most important foundations necessary for new lawyers to begin their new careers and beginning successfully. And they found of the 20 foundations deemed most important to new lawyers, only one was a legal skill, and that skill, frankly, was mostly taught primarily in first-year legal research and writing classes and surely not in the doctrinal classes that students engage in throughout law school. And 10 of the highest ranked necessary foundations were the type of competencies that we also focus on in clinical courses, because much of clinical course is not the nitty-gritty of the skill, but just trying to get the student to understand what it takes to interact with clients and move cases along and meet deadlines. Again, this is not what we students encounter are going to learn in traditional law school courses. And the remaining 9, similarly, with the type of individual characteristics that we encounter in students and have to deal with students, and when they take on the enormous task of representing a client that also are nowhere learned in the classroom. The survey went on, as some of you know, to then ask these lawyers which sort of accomplishments and experiences of a student in the hiring process do you think is most helpful in determining whether that student has these foundational abilities and skills already? In other words, when we look at a resume, what are we looking for that we think reflect the things that we earlier said were important, we think, for new lawyers? And as you can see, it's really the practical skills and experiences that rank high, the most relevant, at least, to these particular lawyers in trying to decide whether they think a student is a good hire. You know, and with all due respect, Josh, to you and Leah, I don't even want you to look at the ones that were ranked at the bottom. And for certain type of legal jobs, as we surely know in legal education, clinical experience is particularly important, especially with hiring into government positions and for legal services and public defender positions. Indeed, I wrote an article a couple of years ago, and I looked at a bunch of ads for public interest and in government positions and found that any number of them actually required students to have some sort of clinical experience in law school for them to look at their particular application. Whoops. Back up, please. Oops.
It's a tricky little bugger.
It is. Just back one. There you go. Sorry. Likes to afford and not back like most of us. So if the lack of clinical training in law school also isn't because recent graduates and hiring partners don't think it's important, maybe it's because students don't want more, right? Well, that's really not true, is it? Right? And we see here pre-law students, and I think that goes for students once they enter law school, overwhelmingly think that we really need a law school model that incorporates more clinical training. Then maybe the problem is that once students get to law school, they're not interested in taking clinical courses. Well, I have run for a number of years a national survey every 3 years of clinical educators and schools that asks about their courses and what's going on, and it asks about demand and meeting demand. And you can see here, it's truly amazing to me that literally over half of all clinics are turning students away, which means these students are being denied the opportunity that they most want. You might ask if that were happening in some other important part of the law school education, whether we might do more about it. A survey of issues with the third year of law school, one that, as you know, many people, and most recently Justice Gorsuch, thinks needs to be eliminated or greatly reformed, concluded that more clinical training could address some of these problems that we encounter in the third year, if only schools were willing. So I want to ask, right, what's the problem? And so let me address a few of what the pushback sometimes is, which frankly I'm going to call tropes, because I just don't think it's true. One worry that's expressed a few years ago, particularly when bar pass rates went down, was that if students are taking these clinics and externship courses, it's just taking up too many of their credits. So in other words, students are going to have trouble passing the bar if they have too many clinic or externship credits. And we just don't find support for that. We surely don't find support for that in a really wonderful large study by the California Bar that found no relationship between the number of credits a student obtained in a clinic or externship courses and their performance on the bar. And a few years ago, I did a study of 10 years of law school grads at my school and at Wayne State, and across a number of dimensions. I just show one here. We just couldn't find any correlation between how many credits a student obtained in law clinics or how many credits in externships or other experiential courses and their likelihood of passing the bar regardless of where they ranked in the class, which is, I think, again, an argument you often get is people in the bottom of the class need to run away from these courses. We just couldn't find that at all. Well, maybe the problem is with more clinical courses is that students will not take bar subject courses, the belief being that it's super important that students take the very subjects that are tested on the bar, and if they take too many clinical courses, they won't take this. Again, in this extremely extensive California study, they found no relationship, positive or negative, interestingly, between taking or even performance on bar subject courses and passing the knowledge portions of the bar. Well, here's the big, elephant in the closet, I guess. Perhaps law schools are justified in not providing more clinical training because it costs too much and would therefore drive up tuition. This is just not so, according to, again, a big study I did. Schools that require a guarantee of clinical experience to all their students were found not to charge more in tuition than schools that don't provide their students with that opportunity. Schools that offer more opportunities and enroll a greater percentage of their students in clinical courses, likewise, do not charge more in tuition. And the schools with what are deemed the very best clinical programs in the U.S. News' annual rankings do not charge more than schools whose clinical programs do not show up in those rankings. And let's not forget about the enormous public service value that law clinics in particular provide to the communities around our universities. And so I might end by repeating what the Dean of Berkeley Law is often asked, and surely which these other professions have already figured out. How in the world do we think we're preparing students for the practice of law without ensuring that every student has taken a clinic and dealt directly with a client's legal problem. So I'm going to end with this. Try to end with this. It used to be this cartoon pogo. And ask if current students, recent grads, new lawyers, experienced lawyers, judges, all see the need for and want more clinical education, then what's holding us behind? Thank you.
Thank you so much. And as you heard earlier, this law school has over 25 clinics. I always tell my law students, or my former law students here, that that is the single most important experience that I think that they can have in law school. So as I thought about this panel, I thought about myself as a PR professor, and thinking about sort of why we teach PR in law school now, right? It's because of Nixon and Watergate. And the last time I taught in this classroom was 2020. So, you know, it was spring of 2020. And so much has changed since then. And so I was curious, you know, what among the pandemic, George Floyd's murder, January 6th, how do we see that impacting the curricular changes going forward?
Wait, why is everyone looking?
I can go first. I think there is a commitment to change, especially on bringing more social justice concerns into the classroom. And I think professors on an individual level absolutely want to do that. But it's very difficult to make curricular change within law schools. There is just a lot of different parties. There's a lot of history. It is every time that any school that I've been at has tried to adjust the first year curriculum, it automatically devolves into a huge fight among the faculty, and then nothing gets done. So I think we do have at this moment the opportunity, because there is a commitment to, because the injustices are laid so bare, there is at this moment the opportunity to do that. But I know some schools are trying to push forward in very real ways, and I think we should take advantage of it.
Well, you'll note that the people that drove the change post the time period you're talking about is the ABA. They're forcing schools to do it, you know, and because I've sat in those faculty meetings, as we all have, to see just how difficult it is to really get real change. And it's interesting, it was the ABA that had to sort of top-down make that on us.
And the only thing I'll add is, because I don't know if the students realize this, but it's often impossible to get professors to change what they teach. Like, they will just resist. So you have that resistance, they don't want to change. And also, you know, I wonder what things would be like if the bar exam were not in the picture. Because one excuse for not changing the curriculum is like, oh, well, we still need to teach this because it's on the bar exam, and that's taking up all the space I have in the classroom, so I can't really change that much.
Right, and that is sort of leads me to my other question, which was the extent to which you see or believe that the ABA, either for good or bad, or academy norms, the bar exam, faculty norms, you know, are those sort of pushing us forward in some cases, or are they holding us back? And if the latter, what can we, who feel like we have a group of interested, engaged faculty and practitioners, what can we do to push through that, do you think?
Well, I was really excited to hear about the changes that the bar exam is making, because I think as far as bringing in more experiential education into law school, it will push schools to do that if they want to train their students in ways that will enable them to pass the bar. But I don't know, I also wonder, like the Carnegie report and a lot of the, that really pushed us more towards skill education and pushed us more towards experiential education. But also in the Carnegie report, it talked a lot about the concerns that Professor Mertz had, that when we train students in this way, that we are taking justice and morality out of the classroom, that they come in with this sense, this intrinsic sense of right and wrong, and we kind of train it out of them. And then that's a problem too. And I mean, that's probably not a bar exam fixable problem, but I do wish that there was some kind of external pressure on law schools in order to bring more of that in.
I mean, one pressure, and I think this is less about what we can do or more about how we can step back, is at so many schools, like it's really the students sort of driving for change, and it's really about I think us sort of stepping back and sort of listening and doing what we can to sort of incorporate what students want.
Nice. Great. So if there are questions, yes.
Thank you so much. I really enjoyed this panel, and I'm a little hesitant with my comment or my thought, but I find that one piece that I feel like is missing, and I know this is about changing legal education, but one piece I find that's missing is the discussion of stare decisis in the common law system. So, in fact, I don't think it's emphasized enough in the 1L curriculum that there are different systems. We are in a common law system and not a civil law system. Therefore, it's not I can't believe I'm defending the Langdellian method, but if you look at the way law develops, if you're looking for change, right, it's not just the way we teach, it's our common law stare decisis system, which values predictability, transparency, and the idea that that the citizens need to know need to know how to expect what is legal and what is illegal. And in a way, already in the Langdellian system or in the 1L curriculum, if it was framed more in that way and people that we could actually talk to students about the fact that there are civil law systems, it doesn't have to be that every case that is published binds future. Like our system, it's not necessarily legal education, but our system is premised, if we look on what education is built on, is on stability and on status quo. That is what this nation has decided is the best way. So, in fact, I believe that every single case in the case books are actually representative of a change or an articulation of a new rule. And it's embedded there, and I believe that there is an opportunity to bring more attention to that, but somehow the legal education is criticized instead of, we're actually teaching or showing through individual case-by-case facts how the law did change, or how the law did develop. And the questions that Professor McMahon that you were asking, already with good law faculty, I believe, are being asked. Were these the right facts to make the right rule? And that we're actually teaching, I don't think it necessarily has to be the case that the Langdellian method leads to the neutrality problem, the justice problem, the thinking out of the box problem. And I just wanted to get your thoughts on that.
Yeah, that's a really great question. So one tension that I've been thinking about a lot as I've been writing this paper is that there is a lot of value in stare decisis. And so much of what I'm pushing against is we have these problems with the laws as they exist and the rules as they exist and the cases that are there. But at the same time, the stare decisis system saved us in 2020, right? The rule of law saved us after the 2020 election, and the fact that judges were willing to abide by the rule of law. And so then so there is value there that I absolutely see and want to preserve. And I'm starting to come to the conclusion that there are ways, and this is basically what I tell my students, that there are ways within the common law system, like through the process of rule synthesis, through the process of new cases and new facts coming to light, to evolve and to change things over time. But the way to make really radical change, I don't know is possible through the common law system. And so what I've started to do, especially in my upper level classes, is give our law students more training in systems outside of the common law. How can you be an advocate in the public? How can you write op-eds that would be really effective in getting public support for changes? How can you petition your legislators to make statutory change to actually move the law forward? And so that's where I've been focusing a lot of my efforts beyond the first year.
This is great, thank you. I have so many things rushing around in my head. One thing I was thinking about when you were all talking about change, and I think, and we always, a lot of times we go back to, oh, the professors are married to what they do, they don't want to change. And we had someone come talk to a committee, and I wish that would have been the whole faculty, but talked about change-driven leadership and what that looks like. And it was so empowering to me to see that those who want change are super excited about it and they're really driven. But when you introduce that change to people who don't know anything about it, there's this chaos that ensues. And it causes people to be very defensive. And that questioning, they start to question, and it's very chaotic. And this person who, she's a psychologist, but she talked about that needs to be valued and normed. Like the chaos and the storming that happens in change is normal. And that, and then once you normalize that, people can start to come out of that. And I thought that was really valuable when we're talking about changing the bar exam, because I can tell you the fear of the next gen, even among my colleagues, is really, it's fear. And I think that can be normalized. And if you're going to change your curriculum, it's the same thing. People go into chaos in that change process. And so I just think I would like to see more people writing and thinking about change agents and what that really looks like. And how do you really effectuate change and normalize the bad feelings and the storming and the chaos. So I just thought I would add that. It's not a question, I'm sorry. Unless, how do you feel about it?
I love it.
Yeah, same.
I'm a law student. One of the other pressures that I think didn't get talked about explicitly, but I see just the huge elephant in the room, is what I see is frankly the really corrosive influence of big law firms on the law school curriculum. And this just sort of underlying assumption in so many classes that so many students are going to go into corporate defense firms afterwards. And I think really imperils that initial question of questioning what the rule is, if eventually you're just going to work for clients who need you to apply the rules as they are. And so I'm just wondering if you could talk a little bit about those pressures.
So I think in large part that's why it's so important that we do this work in law school before students get into practice and face those pressures. And we, in law school, have the opportunity to have students really think long and hard about what are my values? What does a good legal system look like to me? They will not have the opportunity to do that oftentimes after they graduate. And so, yes, there are those pressures from big law, and yes, I do think we need to train students so that when they get to a big law firm, they can operate effectively. But I want to take this time, the 3 years that they have with us, to get them to think about, well, what's meaningful to me? And how can I use my position as a lawyer to actually make change, even within these systems that I'm operating within, even within big law, even within government, wherever you go. And I think that's the rare and precious thing about law school, is that we have that time with them to get them to do that deep thinking.
I'm going to agree. I just want to add one thing, because I think my ideal law school would do that, but it would also it would also be there for the students who have no interest
Right.
changing things. They really just want to go to a firm and make lots of money.
Right.
So
That's totally cool.
It would be totally cool, and it would also be a welcoming place for the students who actually do want to change the world. And I think right now we overemphasize the students going into private practice who are going to, like, you know, keep capitalism going. And we don't do enough for the students who just want radical change.
I actually wanted to unpack a little bit that final slide about the enemy is us. And I think the influence of big law firms is part of that. It influences everything in law schools, from the salary of law professors. I started teaching almost 40 years ago. My salary is much higher now. Well, I'm sorry, I'm retired, but it was much higher, even accounting for inflation, because law schools felt the pressure to keep up with those big law firm salaries. Two others that I think we need to name are that law schools spend a lot of their money buying those LSAT scores. And they spend a lot of their money supporting faculty research. Not only did my salary go up over time, my course load went down so that I would have more time and more money to do research. So I think Bob's point is absolutely right, that more clinical education, those schools aren't charging more tuition. They're just making different decisions about where they're putting the money. And I think it's important for us to recognize the forces in law schools that keep arguing against more.
So I want to actually respond to the student's point about big law and sort of some of the conversation here. And I want to suggest that learning how to apply the law as it is actually extraordinarily valuable for lots of different things. So I think in terms of like this person who's going to go out and be a public defender. Like, there are huge problems with the criminal defense system. I'm not going to talk about it because I've got an expert on that sitting in the front of the room. But it's not a surprise that there's huge problems, systemic problems. But if you get assigned a client, so the first sort of assignment my students do forces them to sort of analyze whether their client was in custody for Miranda purposes, right? When he was interrogated, wasn't Mirandized. And we talk about all the problems with like the way the custody question, how divorced from reality the sort of assumption is about what a police sort of individual interaction is like. At the same time, that public defender has to be able to apply the law as it is, because if you don't know how to do that, you're not going to be able to represent your client well. You have to then also be able to understand why the law is as it is now in order to be able to push for change. So one thing I emphasize to my students, taking like the sandwich example, I really want to dig into and know, where did that definition of the sandwich about the 2 buttered pieces of bread come from? Because if I want to train them to be able to disrupt that as the sandwich definition we're going to use, you need to be able to learn to understand where it came from and use it, so you can then show why it's so problematic. So I think there's actually a lot of value in learning what the law is and how it got there, and here's how you would use the law on behalf of your client. That's the foundation for now go change the law, right? I think you have to have one before you can have 2. And I see a lot of students just want to go right to number 2. I want to disrupt the law, I want to change it. And I want to say, learn how to use it first, because that's going to give you the tool you need, or one of the tools you need for the disruption piece.
I was going to piggyback on what was said here about the clinical issue, and what I thought, I thought it was an interesting slide that says that the schools who have clinics aren't costing more. Because I think there's a lot in there too, and what I found when I was at schools was that there was always a trade-off between clinic and legal writing faculty, and that, like, I was at a school that had a large number of clinicians, but then they wouldn't add to legal writing, and that was all taught by adjuncts. And so I do think that there's a lot more into that slide that could be helpful, because I think there are 2 things, at least, that I found that seem to be impacting whether or not people are able to get a clinical education. One being where they're spending the money on faculty, and 2 is like the culture of the faculty. Does the faculty feel threatened to have too many practitioners? And so I found, like, in arguing that those 2 things, the cultural piece and then also the money piece, it was very difficult. But I felt like it was like an aha moment when I realized, oh, you have a lot of clinicians but not a lot of legal writing folks, and they're not spending a cent more. This is the balance, and I think that's, the school maybe wouldn't cost more, but they're losing somewhere else. And so I think, clinics are amazing. I just adding that as like a piece of the puzzle, which I think is bigger than I think a lot of people would like to.
Right, and one thing that I would add is status, right? So often, clinical faculty, skills faculty do not have the same status, do not have the same salary, and so although we say that these are the most important courses, often they are taught by non-tenure track faculty at a much lower salary or adjuncts. And so that is something that I think we need to think about as part of this equation. One more?
Well, I would love to ask a question. I know we're short on time, but I'm going to take advantage of my position, hopefully before we can go to lunch. I would love to follow up on something that Professor Capers mentioned in response to Professor Lee's last question. You talked about law students being part of the solution here in really asking kind of for what the education is that we want to see. And I would love to hear either you or other folks on the panel talk more about that. For us as students, how do we actually do that? What do you see as effective advocacy for students? How do we make the best use of our short time to be partners with educators who are looking to make these kinds of changes?
I will just say, obviously, it's for students to figure out. I don't believe in top down. Like I'm telling students, this is what you should do. But I will say one thing I see time and time again is the system is almost designed for students not to have input because you're in and out in 3 years. And you'll see students agitating, and then they graduate, and they're not creating sort of like a through line where people behind them will keep agitating. So for me, the most important thing is 3Ls need to get 1Ls on board and keep pushing and keep pushing and keep pushing. And schools want to be pushed. I mean, they might pretend they don't, but a lot of schools will secretly say, this is what we need. We need to be pushed so we can go to law firms, we can go to donors and say, we need more money to do X because students really want X. And in a way, it's a win-win.
Let me just say this: in my 30 years and being associate dean and starting a bunch of clinics, a number of clinics that got started at my school is because students bothered the dean and kept bothering the dean. Yeah. And so I think that students should be vocal about what they like and don't like, and I think, for example, when I hear someone told me the other day, well, I didn't get into the clinic I want, damn it, go tell the dean that, and go tell the dean that that's not right. That's not right, that this is your chosen area of the law that you're going to go into, and that you were denied the opportunity in law school to get the best training for that. That would never happen in medical school. It would never happen anywhere else. And so I think be angry and push. I'm not saying it's easy, and I'm saying it's always going to work, but, you don't need to be polite.
No, I was just going to agree with Professor Capers, because what I see are students who have passion and really start to push the administration, and then they graduate, right? And so maybe using student groups to facilitate that, having student groups that have a particular mission of pushing for something within the school, and being sure that that student group stays true to that mission over time, I think is potentially could be helpful. It's a great question.
Great. Well, I think that is all of the time that we have, but thank you so much to all three of you.